can I invite our next speaker, Professor Albert Lee. Now, without reading too long a CV, Professor Albert Lee is Clinical Professor of Public Health and Primary Care and Founding Director of the Center for Health Education and Health Promotion at the Chinese University of Hong Kong. And today he's going to talk about alternative dispute resolution for medical mishaps, the role of arbitration. Over to you, Professor Lee.
Thank you, Dr. Pei, for the very kind introduction, and thank you for inviting me to participate in this very highly educational event. I'm very privileged to be involved, and I look forward to also learn from all of you as well. Well, tonight's topic, why we talk about ADR, alternative dispute resolution. I think 3 years ago, Terry Khan, the former co-director, organized a workshop, and I was also involved, and aroused a lot of interest in look at ADR. And then I think we could take on further. Particularly tonight, I tend to focus a little bit more on the concept behind arbitration, and which is not widely used to resolve medical dispute, as far as I know in Hong Kong. Mediation start getting momentum, but still not full blown. But definitely arbitration is quite new, as far as I know. Also not used a lot in US, not a lot in Australia or in Hong Kong for the medical matters. And then we could discuss what matters not for arbitration and some of the issues like confidentiality, public interest, and public policy. That could be a big concern for people on either side decide go for arbitration or not. And little bit other outlook for arbitration in healthcare. Okay, now basically, patient or anyone suffer from injury as a result of medical mishap, going through a long period of trauma, we want to repair it rather than causing further injuries or damage. Just to recall an example, this afternoon, I saw a patient whom I've been seeing her for a long time. 2 or 3 years ago, I couldn't even recall. She suffered from an injury of the tear of the rotator cuff of the left shoulder, right? And during her work, all right? So it's become, well, she labeled as an acquired injury, she have surgery done, all right? And has been over the last 2 years, there's still dispute between the employer and herself whether her injury is occupational related, right? If it's not occupational related, the employer could wash her hand off. And I have to write supporting statement for her that she did not have this kind of injury, existing injury or illness related to left shoulder before. And this afternoon, she told me that finally the employer admitted this occupation injury, and they're willing to discuss, and the whole process will not go to litigation, it's going to mediation, or well, they'll come to it, but it's been lengthy process. That will actually definitely happen even just at the beginning of the COVID. So now it's going on for 2 years. So it could be very, she actually say very painful, and I don't know, coincidentally or real, she only had borderline high blood pressure a couple of years ago before all this happened. Now she's on treatment for hypertension. I'm treating her at another new problem, okay? Are they coincident or not, I don't know, but definitely could be very painful, all right? And we all know that under any medical intervention, it's not risk-free. We're dealing, if we want to provide risk-free intervention, very well not to do anything. So whatever we do, we always balance the risk and benefit. So things could happen, and then we could see how we could deal with it better. Well, I went through this already for many of you in the commercial sector already using a lot alternative dispute resolution for other construction, family dispute, but not a lot in medical disputes. Start mediation, but still not that many cases. I learned from my great friend James, who's doing a lot, but still not as much as we could see. And I think in one of the conferment ceremony, the former Secretary of Justice, Mr. Rinsky Yuen, mentioned with the Hong Kong College of Otolaryngologists, and thinking that ADR should be used more for medical dispute. And also echo Lord Wolf said in a seminar a decade ago. A quick recap: mediation. Mediation basically is getting a mediator, try to facilitate the two parties to come to some settlement, right? The mediator is not a judge. in a way, not judgmental. It's trying to basically facilitate to get the two-party talking and reach agreement. And finally, the agreement, the settlement is a contract, right? If either party decide not to go along, then you still have to take them to court to sue for breach of contract. So it's basically a contractual agreement. Arbitration is basically an independent third party, right? Can be one arbitrator, 3, 5, or 7, right? Or usually 3, all right? And it's function like a court, right? But rather than the court doing it, some people call it underground court, but it's not quite, because the whole arbitration process is governed by rule of law, all right? And basically, we talk a little about it, there is governed by the arbitration agreement. The arbitrator and got to apply the set of law that stipulate in the arbitration agreement, and they still have to conform to the rule of natural justice. It's not just because our arbitrator, they do whatever they want, right? A little bit more. The philosophy behind arbitration, all right? In Hong Kong, you have the arbitration audience, which model on the ancestral model law, all right? And some modification or supplement. So it's governed by law, all right? And then UK, the English Arbitration Act and things like that. And basically, it's an impartial tribunal, right? It's the independent tribunal. And then it's the both party will choose the arbitrator. So it's a consensus process and drafting the arbitration agreement to decide how the whole thing to be arbitrated. So this will give the jurisdiction to the arbitration tribunal, right? The arbitration agreement also governed by the law, right? And then they will decide in terms of the contractual agreement between two parties, how they apply the substantial law. Right? Sometimes this intellectual arbitration, the seat arbitration might not be where they're doing business. Then they have to decide what will be the law governing the contract, and they will decide what's the law governing the arbitration process. All right, in Hong Kong, it's governed by the arbitration audience. So there's a set of law governing the arbitration, and also the rules. For example, in Hong Kong, you have the Hong Kong Institute of Arbitration, Council Arbitration, the Hong Kong IAC rules. There's rules. So there's a law governing the whole process, the rules governing the procedures, okay? And basically, the court will not intervene unless it's stipulated by the law, right? Okay, in Hong Kong. I think it's similar in the other country. So the arbitration tribunal used to have the jurisdiction to decide whether the competency to resolve the matters, okay? All right. And again, it's a finality of the award. Basically, once you got the award and it's binding, right? The party can go to the court to get enforcement, all right? And basically, the challenge against the award is not on the substantial issue, usually unless the arbitrator violate the rules or they're incompetent and the whole thing become a breach of natural justice. Not arguing the more detail about whether this is a fair judgment or not. It's basically the fairness is the procedure, any irregularity of the process. So the court usually regarded it, especially in Hong Kong, is for arbitration, unless it's obviously wrong, all right? Okay, all right, so it's one thing. Now the advantage is, particularly, you can choose the expert involved in arbitration. You take the matter to the court for medical matter. The judge is very, of course, an expert in law experience. But when you come to technical matter, that's why they start using it a lot of construction industry. For example, definitely you call me to arbitrate a construction matter, that will definitely no, because I don't understand the detail. So a lot of engineers also serve as arbitrator, okay? So you want to find the subject matter, the expertise. If you say a medical dispute, definitely you need some medical personnel. You may want people with legal background to look at the whole process. And if it's suing for damage, you may want someone who actually able to calculate the cost, all right, or the ballpark figure or how to pay in terms of what the damage. So you can have the different expertise together, all right? That will speed up the whole thing. Otherwise, because if they rely on the judge, and depends, some judge may be very experienced in certain cases, but may not be, right? And then the whole thing is the two party come to consensus agreement to choose the arbitral tribunal, all right? All right, so they reassure the impartial, but you can't argue because it's consensus by both parties, okay? And then you could accommodate certain particular cultural legal different, all right, the cultural perspective. Okay, let's say you have a dispute related to traditional Chinese medicine. You may want someone understand traditional Chinese medicine, and then you all agree the expense and then how you resolve the conflict and what rules to adopt. And the other good thing about arbitration, you have different award. You can have an award for certain matter, all right, and you can even award for even apology. Well, that's one example, or some specific performance, okay, or money. So it's different kind of award, and you can also issue interim award, right? So before the whole thing settle, okay, all right. So that's the beauty of arbitration. Of course, there's some concern. Now, doctor-patient relationship is not like commercial, right? And the doctor-patient relationship can be also governed in terms of it's not just simply a contract, could be a tort, or could be also the standard is expectation by the society, and is professional determine the standard of care, right? So it's not quite the same purely commercial matter or some in a construction business. And doctor-patient relationship, people say, is never the equal footing, right? Because the doctor usually by default they have more clinical skill and knowledge in the matter, all right? So could you put the patient unfavorable condition? In US, usually, whenever they enter some managed care, they may be asked to sign arbitration agreements. That means the agreement arbitration, right? That means if any dispute, you have to go for arbitration, right? So at that juncture, could it be fair for patient to decide the matter, all right? Okay, that is one concern, all right? But I think the first part is agreement to arbitrate. The method to be arbitrate must be that reasonable person could understand that it's fall within covering the illness. Okay, but usually I guess in Hong Kong and basically we've never asked people to have this arbitration clause when you go and see doctor. When you enter some business or apply for credit card or things like that, be aware you might be asked any matter, any dispute will subject to our mediation, arbitration, according mediation order and arbitration order in Hong Kong. So basically you can't take things to court. But I don't think we have this at this moment, this kind of precondition. But a lot of things will be after the incident. Okay. Now the potential, I think I mentioned, I will run through this quickly. The rules been also the rule can govern how many expert you want, and you could end up a neutral expert, all right, an independent expert. But also they still use the hot tapping, just one increasing advocate using one expert, all right, and represent both sides, because suppose we have medical expert witness, we are duty to either medical counsel or to the court, okay, and you can select the arbitrator, and then if you design it well, it could be cost saving. But obviously I must stress that if the process setting up arbitral tribunal or panel is not systematic, not administered, the rules never stipulated well, and unclear which law you apply in terms of the seat arbitration or the law of arbitration or the law governing the contract, the whole process could be going in the haywire, and then it will be open up to challenge the court. Okay, certain matter might not be arbitrable. For example, I won't go through detail, criminal charges or relating to divorce, marriage, and parents and children. Okay, and those are the sort of thing might nationality and things like that, but may not be. I think anything with no criminal charges, okay, cannot be arbitrated, or anything matter reserved for the agency tribunal. For this matter, maybe some social welfare settlement. Now, the High Court basically can restrain arbitral proceeding by injunction, but they really make its threshold is very high. And basically, the court, they try to support arbitration and avoid unnecessary interference, unless it causes in sort of breach of administrative justice, is breach of administrative justice. And sometimes, or alternative, the proceeding of arbitration become very oppressive or abuse of process. Okay, all right. And the court usually will defer to if it's already agreement arbitration, they will defer the arbitration tribunal to decide whether the matter of to be resolved by the tribunal, all right? And as long as there's a valid argument, okay? And basically, even the agreed arbitration, again, emphasize cannot do anything against the law. be found illegal in Hong Kong, the matter be arbitrated is illegal or strong contrary to public policy, which I will come on to that later. Okay, so to summarize, and basically, if a medical dispute involve a criminal act, serious fraud, in bad faith, serious offenses, or anything caused death or grievous body injury, those should be either court or even the death or coronary court, and those are the sort of thing might not like criminal act, maybe like the gross negligent manslaughter. Those are actually will be a police case. All right. Okay. All right. Now, people worry about the confidentiality, the information, because arbitration, mediation, all the process is confidential, where both parties are bound not to disclose any information. All right. Even though the arbitration failed or the mediation couldn't reach any consensus or arbitration process, someone could fail, but they still is obligation to not to disclose information. But I think people worry, how happens if I take the case further? I think if the claimant is going to arbitration, then he or she may have thought about it, unlikely to go to litigation. Okay. And again, the challenge of arbitral award I mentioned earlier on require very strong ground. And if the claimant or arbitration will resolve medical disputes, and unlikely they complain medical counsel, they understand if they really concern the doctor's professional conduct, they really want the medical counsel to deal with it, then they will. All right, they will go along that way. If they go along the other way, probably they want some remedy, some other thing. They may want more than just a ruling whether the doctor is negligent or breach of duty of care and then the medical counsel, as you know, is basically dealing with disciplinary against the doctor. They're not going to award damage or remedies. Okay, but of course, the medical counsel can investigate complaint by other person. Let's say you have A against Dr. B. Maybe the Dr. B become income and make some mistake and things like that. And then suddenly a third person C realize Dr. B is suffering from severe cognitive impairment, unfit for practice, and could still complain to the medical counsel. But then the inquiry panel or the health committee or medical counsel can summon witness. And that comes to earlier point that, and I will come to later, because become a regulatory authority. I don't think it's any case been tested in Hong Kong yet, but that could be a case, right? That the disclosure information and I won't say breach of confidentiality, but that could be exception to disclosure information. However, that could be a really serious matter. If the inquiry panel decide to take on, that must be a serious matter. That, in a way, protection of public interest. But I think when come to if it's only at PIC level, I doubt very much, based on some of the previous case that the PIC could summon witness, especially the both parties are bound by the arbitration agreement that to uphold confidentiality. Okay, so there's certain I won't go there the matter of time, and basically disclosure information, basically very similar to us. We own confidentiality of the patient. It's not 100%. It's only under special circumstances we will disclose information, right? Again, is protect the interest of the party. The interest is not general interest. It's interest in terms of the legal right or even the life and death situation. If we don't disclose, it may cause serious harm to the public. So I think the threat is that kind of threshold. You think about ourselves as a doctor, under what circumstances we may disclose patient information. It's not lightly. It's either by statutory requirement, notifiable disease, all right, or something the matter we think very serious. We don't disclose, we will doing harm not only to many people, to the patient, to the person, and not to the public. Okay, all right. So again, required by competent regulatory authority. Could medical counsel? Probably yes. But again, it's the counsel inquiry or the health committee level. All right. And you look at the because the exception is actually modeled on the New Zealand Arbitration Act. The public interest is the big word, right? But the public interest is basically the threshold is the interest of justice. All right. It's not just general thinking. All right. Oh, that's good to disclose. Okay. So again, the public threshold is very high. Okay. And so that's a big consideration, okay? And based on fundamental principle, obligation of confidentiality is applied by law and nature arbitration, and is the only time is by leave by the taker of the court where the reason necessary to protect the legitimate interest of the party, all right? Or also in the interest of public policy, Okay, the public policy against some definition is basically is a contrary public policy is mean contrary to the morality and justice of the forum. Basically, it's a very high threshold. It's not to be used lightly by people to challenge arbitration. Oh, you breach a public policy and try to escape the result of arbitration. Okay, and it should be quite clearly, explicitly decided by law and the cases, not just because, oh, I feel it's a political decision. Never shouldn't be like that. Okay, all right. Oops, sorry. So now I come to, because I'm sorry, a bit rushed because I'm cautious with time and some recent development. And I think I won't maybe have a lot of time to go into detail, but I draw attention to the arbitration and mediation legislation, third-party amendment audience, and basically add on allow third-party funding. It could have implications. Could be positive, could be negative. We need to maybe some other time to talk about it. Usually in the past, it's not allowed, okay? And now it's allowed, all right? That's third-party funding. So that means is someone else fund the whole process, okay? That could have strong implication. That's just like to draw attention. And in 2021, and the UNCITRAL expertise rule, and because UNCITRAL model law and model the rules, and actually a lot of people more use it because it's an international benchmarking. And I think that is in relation to COVID, basically could allow the party and arbitrator to conduct arbitration expeditiously because it's more avoid delay and using appropriate technological means, and a lot of them is now doing online because you need to have the modification of rules. And sometimes you may only can find one arbitrator and could dispense oral hearing, could be just by paper and documentation, right? And got to be within 6 months or after constitutional tribunal to allow the speedy resolution of the process, okay? And then the party agreement, particularly related to investment. Okay, further, just finally, I want to finish off and talk about the future outlook arbitration. Apart from just dealing with doctor-patient at that level, all right? Okay, that could be some disputes, all right? And due to the metal misgap causing some body suffering. But some other complaint could be due to arbitration rather than bordering or drop burden the medical counsel, medical necessity. I know there's a lot of complaint saying that, well, I think if the doctor over-investigate me, I don't think I should be referred to this, I should not have a CT, blah, blah, blah. That could be one way to resolve. Because when you go to medical counsel again, at the end of the day, is decide whether the doctor is below the standard. But that's it, full stop, and suddenly the complainant may say, oh, how about compensation? No, that medical counsel is not dealing with it. But arbitration, yeah, you feel unfairly treated by the doctor, doing some intervention unnecessary, you may want some compensation. Arbitration can deal with it. Charging high fee, this could be another one, all right? And for example, I just read one question, doctor failing to pay debt, complain to medical counsel. Well, I don't know. We can write to medical counsel, but then medical counsel has to open the file and decide. If this is the case, that could be arbitration, right? If the doctor say, oh, I should offer 10 counseling sessions for you, now you only offer 5 and you owe me something. That could be another word. That could be, all right? And a lot of insurance dispute, right? Between and like my case, right? And I just mentioned early on, okay? Credentialing or medical staff, oh, maybe one hospital decide could not granting me admission right or not recognize me to perform particular things, rather than going all the way to court, that could be arbitration because you can find an expert here. Or maybe you say the doctor, the hospital say, oh, you can no longer do this operation because I think you're unfit, and then you feel it's unfairly dealt with it, all right? Well, basically, that could be arbitration. Some contract, employment contract between the doctors and the others, or medical helper profession and the others, and dispute within the medical practices, or some other example. And if the doctor leaving a group practice, they are not allowed to practice within certain distance and not within certain number of years, not seeing the patient of belong to group practice, could be, and maybe some area, some gray area, then that could be arbitration, okay? And more with managed care between the providers, the service provided by healthcare provider and the payer, all right? And then that could be a contractual agreement. This, for example, we tend to look a little bit forward with the advanced medicine. There's so many other issues could happen every day to us as a doctor. and may not be directly with just the treatment we giving the patient, but other aspects, or also how do we deal with healthcare provider, or dealing with lab, dealing insurance company, or patient dealing with a medical insurance. All these things could be also looking at arbitration to resolve the issue rather than going to court and find the right expert in. Okay, so with that, I think I will finish here. Sorry, a little bit stretch over time, but I look forward to any further comments from you, enlighten me further. Thank you very much.